She looked me dead in the eyes. Right there in the hallway of that courthouse I knew by heart, every column, every crack in the ceiling tile, every door that sticks when you pull it, and said, loud enough for everyone to hear, "You've been cleaning this courthouse for 12 years. I know you. I've seen you on your knees scrubbing the floor of this very room, and now you're going to sit behind a case like you're somebody's lawyer?" The hallway went quiet. I felt the blood rise up through my neck. I felt the weight of every set of eyes, every attorney, every paralegal, every clerk who had stopped to watch. These were people who had seen me crouched over a mop bucket hundreds of times. People who walked past me for years without saying good morning. People who were now looking at Denise, the cleaning lady, standing there in a black blazer I bought on a payment plan, holding a leather portfolio, her bar card hanging around her neck on a lanyard. My hands tightened around the portfolio, but I did not look away. Paulette Ashford Crane, wife of Judge Warren Crane, president of the Atlanta Bar Association's private membership club, a woman whose name appeared on every invitation list for every fundraiser dinner in Buckhead that mattered, was looking at me with the kind of contempt that only grows in people who have never once had to wonder whether they could make rent. She had no idea that I had studied in that courthouse. She had no idea that every case file that passed through my hands while I cleaned those hallways had become a lesson. She had no idea that I had spent 10 years in night law school, paying tuition with that same cleaning salary, sleeping 3 hours a night, arriving before the attorneys every morning, and staying after everyone left to study in the service bathroom with my casebook balanced on my knees. She had no idea I was a lawyer, with a bar license, active standing, 2 years of practice, and 12 years of courthouse in the soles of my feet. And she certainly had no idea what I had found in that case file she wanted me to walk away from. 3 weeks after that hallway, Paulette Ashford Crane walked out of a hearing with her reputation intact on the outside and shattered on the inside, because the people she respected most had seen, with their own eyes, what happens when someone underestimates the cleaning lady. If you've ever been treated like the work you do defines how much you're worth as a human being, stay with me, because this story is about a lot more than one court hearing. It's about what happens when invisible people stop pretending they can't see. Tell me in the comments, has anyone ever judged you before you opened your mouth just because of what they assumed you were? Leave a like, subscribe to the channel, and let's start from the beginning, because this story needs to be told from the first day I ever picked up a mop inside that building. I came to Atlanta at 23 years old with a duffel bag, a broken wheel on my rolling suitcase, and the address of a cousin who lived in East Point. It was 2006. I'd finished high school in Macon, Georgia, and my mother had scraped together $400 to put me on a Greyhound and send me to the city with the promise that there was work there. She wasn't wrong. Atlanta has work. Atlanta has plenty of work for someone willing to do what people with money don't want to do. Macon teaches you early that the world has two sides, and you need to find your footing before the ground finds you. I grew up in the South Bibb neighborhood, in a house where my mother took in ironing and my father worked a warehouse job until his back gave out. When he went on disability, the household income got cut in half. I was 15. I started babysitting for a family in a nicer part of town. $180 a week, Monday through Saturday, 7 in the morning until 6 at night. I watched 2 kids for 3 years while I finished high school in the evenings. I learned a lot in those 3 years. I learned that rich kids and poor kids have similar dreams and completely different worlds. I learned that when you serve people, you learn to read their moods before they open their mouths. Because if you misread them, you pay for it. I learned to be invisible in a productive way, to be present without being intrusive, to listen without being noticed, to observe without being seen. That invisibility, which I thought at the time was weakness, turned out to be the most powerful thing I ever developed. In Atlanta, my cousin put me up in her spare room for 2 weeks. Then I found a place in Mechanicsville with 4 other women, all service workers, all with stories like mine, all sending money somewhere. We shared a refrigerator, a bathroom, and the collective conviction that we were going to get somewhere better. Within 3 weeks, I was on payroll as a custodial worker with a staffing company contracted by the Fulton County Superior Court. The pay was $13.50 an hour. The shift was 6 in the morning to 2 in the afternoon. My assigned area was the second floor corridor, where the courtrooms were. I was 23 years old. I didn't know anything about law, but I learned fast. The first month I just listened. Attorneys arguing strategy in the hallway before going in, judges talking with clerks about precedents, law students studying out loud while they waited. I pushed the mop and I listened. I wiped down the walls and I paid attention. I cleaned the windows, and I followed what was being debated on the other side of the open door. There was one attorney who always arrived 40 minutes before a hearing and stood outside the courtroom running through his arguments in a low voice. I heard every rehearsal that man did for 2 years. I learned more about civil procedure from him than from many of my professors later, and he never knew I existed. It didn't take long for me to understand that what they did, the law, was a language, and that language can be learned with effort, with time, with repetition, with a lot of repetition. By the 3rd month, I bought my first introduction to law textbook from a used bookstore on Moreland Avenue. $12. I read it 3 times. By the 4th read, I was making notes in the margins with a blue pen. Not summaries, but questions, things I didn't understand and needed to understand. By the 2nd year, I switched to an afternoon shift and enrolled in the evening law program at a small accredited school in Decatur. Tuition was $920 a semester. My hourly rate had gone up to $15. It worked. If I didn't go out, if I didn't buy anything that wasn't essential, if I didn't send money home to Macon that month, it worked. Sometimes it didn't work. There was one semester, the 4th, I think, where I fell 2 months behind on tuition. The financial aid office already knew my name by sight. Every time I came in, they were already pulling up my account before I said a word. It wasn't judgment, it was protocol, but it stung the same. That same semester, my mother needed a procedure, gallbladder. Nothing life-threatening, but it cost money I didn't have and that I raised by selling homemade pimento cheese sandwiches and pound cake out of a cooler in the courthouse parking lot during my lunch breaks for 3 weeks. I had grown up watching my mother bake to bring in extra money. I knew how to do it before I was 10. I sold for 3 weeks, raised what I needed, paid tuition, and paid the medical bill. I didn't tell anyone at the time. I'm telling you now because you need to understand the level of obstacle between me and that bar license, and how I kept going anyway. There were weeks I walked to school from the bus stop, an hour and a half each way in the Georgia heat, because I didn't have bus fare, and I still went. Because quitting was not an option I was willing to put on the table. My civil procedure professor in the 3rd semester, a tall woman with reading glasses, always pushed down her nose, who spoke faster than any human being I had ever met, said once, in the middle of a class on statutes of limitations, "The law doesn't belong to people with money. It belongs to people who know the rules better." She was explaining tolling, but I heard something else. I heard a path. What kept me going was the courthouse. Every single day I walked into that building and saw what happened in those courtrooms, I became more certain it was what I wanted, not the cleaning, the law, the possibility of being on the other side, of being the person who walks through the front door, sits at the table, and speaks for someone who doesn't have a voice. I knew what it felt like not to have a voice. I knew it very well. There were days I cleaned the corridor after a hearing that had gone badly for someone. I could see it in their faces on the way out. And I would stand there thinking about what I would have argued differently, what evidence hadn't made it into the record, what angle the attorney had left unexplored. It was almost compulsive, that mental exercise of reconstructing what I'd witnessed and imagining how it could have gone better. Years later, when I was in law school reading about trial strategy, I realized I had been practicing it for years without knowing the technical name, just with my eyes and with logic. My name is Denise Okafor. I am 41 years old. I was a custodial worker at the Fulton County Superior Court for 12 years, 4 months, and 16 days. I passed the Georgia bar on my 2nd attempt at 38. The first time I missed by 4 points, and cried for 1 full afternoon before deciding I was going to sit for it again. And never, not one single day after I hung that bar certificate on the wall of my apartment in Inman Park, did I stop going to that courthouse, because I had clients to represent, and because, I'll admit it, I liked walking through that door knowing I understood every inch of that building better than most of the attorneys who practiced there. That knowledge, which for years had seemed completely irrelevant, turned out to be exactly what changed everything on a Tuesday morning. But before I get there, I need to tell you about Renee. It was 7:40 when Renee called. I was in my office, which is a second bedroom in my apartment with a desk, 2 chairs, and a succulent on the windowsill that survives because I forget to water it, and it has decided to be resilient. I had 2 cups of coffee in me and 3 open case files on my laptop. Renee, 44 years old, ex-wife of Douglas Fairfield. Yes, that Weston, as in Fairfield Capital Group, as in the private equity firm whose name appeared in the Atlanta Business Chronicle every quarter and whose founder had a box at Truist Park and a profile in Georgia Trend. She had married him at 27, stepped away from her marketing career at his request, raised 2 kids, managed 4 properties, organized 16 years of his social and professional life, and been discarded at 42 with a divorce settlement that her attorney at the time signed without reading it properly. Her attorney, not her. She only understood the size of the hole she was in when she tried to open a credit card in her own name and found out the accounts she thought existed had never been in her name at all. I had been on Renee's case for 4 months. A motion to set aside a marital settlement agreement. She wanted to challenge terms she had signed under duress and without adequate legal counsel. The case was moving, slowly the way everything moves but moving. That morning the call came in desperate. "Denise, Mr. Hines called me. He said he can't represent me anymore. He said he just discovered a conflict of interest." I closed the file I had open. "What time is the hearing?" 10 o'clock. It was 7:40. "Who is Hines partnered with?" He didn't say. He just said he couldn't continue. I already knew the answer before she finished the sentence. Hines, Kerrigan Hines, Brandt and Associates. A firm that handled corporate transactions for half a dozen of the largest private equity groups in the Southeast. Douglas Fairfield had made 1 phone call, said the right words, and within 12 hours, Renee's attorney had discovered a conflict of interest that hadn't existed yesterday. "Renee, I need you to listen carefully. You have 2 options. First, we file for a continuance, citing substitution of counsel. Second, I go there right now and take the case." Silence on the other end. "Can you do that?" "I'm a licensed attorney in good standing. Yes, I can do that. But you don't know the whole case." "I know it. I've read every page 3 times. That's what I do with every case I take." More silence. I heard her breathing. "The problem," she said finally, "is that Mr. Hines told me if we file for a continuance, Douglas's lawyers are going to object and will probably get it denied, because this is already the second rescheduling. The judge has already made clear she won't grant a third." I closed my notepad, picked up Renee's case folder, second drawer on the left because I organize by urgency, not alphabetically. "Then I'm going there now. Meet me at the courthouse entrance at 9:15. I arrived at 8:50. The courthouse in the morning has a specific smell. The coffee cart by the main entrance, paper files, air conditioning that's already been running for an hour. I've known that smell for 18 years, first as a contract custodial worker, then as a direct hire, then as an attorney who was still paying her rent with the cleaning salary while she waited for the practice to grow. I went straight to the clerk's office for the division where the hearing was scheduled to confirm the courtroom number. The clerk looked at me. Black blazer, portfolio, bar card, and didn't recognize me. We had worked the same shift for 2 years. She asked my name and I told her. She still didn't connect it. That's not unusual. When people change context, recognition takes longer. Renee arrived at 9:12. Her eyes were red and her hair was pulled back in a way she never would have chosen. She who, when she came to meetings at my office, always arrived perfectly composed, the way someone looks when they've never had to rush out of the house without looking in the mirror. I understood. When you spend 16 years building a life next to someone, and that person uses every resource they have to diminish you in the process that was supposed to restore what's yours, you show up at 9 in the morning with red eyes. "We're okay," I said. It wasn't a question. She nodded, even if she didn't believe it. We went to the second floor waiting area, and that's when it happened. I saw Paulette Ashford Crane before she saw me. She was talking with 2 attorneys I recognized by sight. From the bar club circuit, the type who shows up at every correct event wearing their firm name like a status symbol. Paulette had on an ivory wool blazer, dark hair cut close at the neck, and the kind of presence that takes up space without needing to be loud. She saw me when I was passing through the hallway and stopped talking mid-sentence. I watched the exact moment recognition arrived. Watched her eyes travel across my blazer, the portfolio, the bar card. Watched the expression shift, not to surprise but to something much worse, that calculated contempt of someone who is about to say something and already knows exactly what it is. Denise, she said my name like it was a joke. Denise Okafor? I stopped. Paulette? She took a step toward me. The two attorneys with her looked over. Renee at my side went still. You have been cleaning this courthouse for 12 years, she said. Loud, clear, unhurried. I know you. I have seen you on your knees scrubbing the floors of this building. A pause. Deliberate. And now you're going to sit at the table like you're someone's attorney? The hallway went quiet. Not the quiet of people who are shocked. The quiet of people who are watching, who are waiting to see what I was going to do. I looked at her. I felt my heart speed up. Not from fear, but from that specific kind of anger that stays quiet before it becomes a decision. I thought of 10 things at once. I thought of my mother in Macon. I thought of the month in 2011 when I had $47 in my checking account after tuition and chose not to tell anyone. I thought of 3:30 in the morning on a Tuesday in 2015, sitting on the floor of the courthouse service bathroom with the Federal Rules of Civil Procedure binder in my lap because it was the only place with light and quiet at the same time. And I thought of Renee, right next to me, with her red eyes, who needed someone who wasn't going to flinch. Yes, I said. My voice came out steady, steadier than I expected. I cleaned these floors, and while I cleaned them, I studied every case file that came through this building. I did not look away from her. I was invisible in here for 12 years, but invisible isn't ignorant. Paulette opened her mouth. Attorney Denise Okafor. I finished before she could speak. Georgia Bar number 412,733. Good morning? And I turned around. I heard, as I walked away, one of the attorneys near her make a low sound. Not a laugh. Something different. Something I didn't need to define right then. Renee came up behind me. When we reached the waiting area, she touched my arm. My God, she said quietly. Don't forget what you just saw, I told her, because the man on the other side of this hearing bet that no one was going to show up for you, and someone showed up. The hearing started in 40 minutes. I sat down, opened the portfolio, and began reviewing every page of Renee's case file for the 4th time, because that's how I work. But before I tell you what happened in that courtroom, I need to tell you what I found in those documents 3 days earlier, because without that, the hearing would have been a different story. Something was wrong with the power of attorney. I noticed it during a late-night reread, one of those sessions you do when you can't sleep because something in the case isn't adding up. The limited power of attorney that Douglas Fairfield had allegedly signed, authorizing Renee's previous attorney to execute the settlement agreement on her behalf, had a specific date on it, March 22, 2022. I went to verify the filing stamp at the clerk's office. The document had been filed that same day, at 2:37 p.m. Then I called Mr. Calvin. Mr. Calvin is 67 years old, with white hair, wire-rimmed glasses, and 32 years of service as a deputy clerk at Fulton County Superior Court before he retired. He has known me since I was 25 and still mopped the hallway outside his office. He was the one who, without any fanfare, once placed a copy of Georgia Rules of Civil Procedure on top of my cleaning card and said, "You read fast. Try this one." I called at 11:30 at night. He picked up on the second ring. "Mr. Calvin, sorry for the hour. Denise, you've been calling me at midnight for 15 years when you're stuck on something. Go ahead." Do you remember how document filing worked on March 22, 2022? Was the e-filing system fully active? Silence for 2 seconds. March of 22, he thought. No, March of 22 we were still in the hybrid filing period, part of the COVID transition back to in-person operations. Until the end of March, any in-person filing required a manual clerk stamp with the receiving deputy's signature and employee number. My heart rate went up. The document I'm looking at has a digital stamp. Longer silence. In March of 22? That's what it says. Then that document was not filed in March of 22, he said. His voice was completely level. The calm of someone who has spent decades in this work and knows exactly what he is hearing. Either that stamp is fabricated, or the document was filed later and the date was changed. I closed my eyes. Can you help me confirm that? I don't officially retire until October. Until then, I still have access to the historical filing records. Send me the case number, and I'll check the original entry log first thing tomorrow. Mr. Calvin, Denise. His voice softened. I watched you study inside a service bathroom for years. If you found an irregularity in a case file, I want you to be able to prove it. Send me the number. I sent it. The next morning at 8:12, he texted me 3 lines. Checked physical log. Date recorded in system. September 17th, 2022. 6 months after the date on the document. Manual stamp entry is posterior. I have a copy of the original log here. 6 months later. The power of attorney that Douglas Fairfield claimed to have signed in March of 2022, when Renee was in therapy and emotionally incapable of contesting anything, had been filed in September, when the settlement was about to be confirmed by the court, when the window to challenge was almost completely closed. The date had been altered, and Mr. Calvin had the proof in the original log entry. I slept 2 hours that night, not from anxiety, from calculation. Because a document with an altered filing date in a court proceeding isn't just a procedural irregularity. It's fraud on the court. The question wasn't only how to use it in Renee's hearing, it was how to use it correctly, at the right moment, in a way that made sense before the judge without appearing to be a surprise attack or a poorly prepared ambush. Because poorly prepared ambushes lose cases, and I could not lose Renee's case. By 4 in the morning I had my plan. But while I was preparing that, something else was happening in the network Paulette Ashford Crane controlled. Paulette was not simply the wife of a prominent judge with money and opinions. She was the center of a specific social control network among the wealthy families of Buckhead, Ansley Park, and Tuxedo Park, that narrow Atlanta circle where everyone knows everyone, everyone attends the same fundraisers, and everyone tracks exactly who was or wasn't included on the last invitation list. She organized charity galas that no one in that circle could afford to decline. She put names on lists and took names off lists. She was the kind of woman who never raises her voice because she doesn't have to. One word from her in the right ear, and the thing happened on its own. I knew this because courthouses are social networks too, and custodial workers who spend 12 years in a building hear a great deal. I had heard when Paulette called the membership director of the club where Renee and Douglas held a joint membership and had Renee's name flagged for removal, before any legal proceeding had concluded. I had heard when she called the property manager of an apartment complex where Renee had applied to rent and had a word that resulted in an inexplicable rejection. I had heard when she leveraged her husband's position, a sitting judge, a figure of institutional authority, as social pressure in situations where that position had absolutely no relevance. It was not declared persecution. It was the refined version of cruelty, the quiet squeeze of someone who knows exactly which valves to turn. Renee told me about each incident during our meetings, in the voice of someone reporting documented facts, not expressing fresh rage, but carrying the particular exhaustion that sets in when you realize the harm was systematic and not accidental. I thought it was bad luck, she told me one afternoon. Eventually, I understood it was her. What Paulette did not calculate was that by deciding to humiliate me publicly in that hallway, she made me a protagonist in the story. Before that moment, I was just Renee's attorney, a secondary variable who could be circumvented. After that hallway, I was the cleaning lady turned attorney she had tried to shame in front of witnesses, and witnesses talk. In the hours after that morning, at least 4 people who had been in that hallway mentioned the episode to others. That's how Atlanta works in those circles. Information moves faster than any court filing. By noon, I had received a text from a fellow attorney who had not been at the courthouse that morning but who had heard from Veronica that something happened. I asked her not to spread it further. She promised. By Atlanta social logic, that meant she told 2 more people before dinner. Paulette attempted to manage the narrative. I heard through mutual connections that she had tried to reframe the episode as, honestly, I just didn't realize she had gotten her license. But a story in those circles doesn't get reframed once the original version is more interesting than the correction. Her pressure on Renee did not stop. The following week, a new attempt. Through a mutual acquaintance, Douglas made it understood that he was willing to handle everything quickly and quietly if Renee would agree to a direct conversation. Without attorneys present, I told Renee not to respond. When someone being sued wants a conversation without attorneys, it is not out of goodwill. It is because they believe they can intimidate more effectively without anyone documenting what is said. Renee didn't go. The week after that, Hines, Kerrigan, and Associates filed a motion to disqualify me, arguing that I had a conflict of interest because I had worked in the courthouse where the case was pending. It was a weak motion, and any attorney with working knowledge of bar rules knows that a former custodial employee of a courthouse has no functional relationship with its judiciary. The motion was denied in 2 days, but the goal wasn't to win the motion. The goal was to consume time, money, and energy, to make the case feel more complicated than it was, to plant doubt that I was operating on unstable ground. That strategy, the attrition play, is the preferred move of people with resources against people without them. It works with devastating frequency. It had worked on Renee for 2 years before she found me. It was not working now because I know that game line by line, and because I do not get tired of a case I believe in. The courtroom had 12 chairs, a long counsel table, a raised bench, and a window that looked out onto the parking deck. I had cleaned that room more times than I could count. I knew where the projector cable caught under the table leg. I knew that the door to the judge's chambers didn't close completely unless you pushed it flush. At 10 o'clock sharp, the Honorable Sandra Pruitt entered. I knew her by sight. For years I had watched her move through the second-floor corridor with her files under her arm, always acknowledging the custodial staff by name, one of the few judges who did. She did not recognize me that morning, but I noticed the slight adjustment in her expression when she looked at who was seated at the plaintiff's counsel table. On the other side, Hines himself was absent. In his place was a younger attorney, Todd Kerrigan, a junior partner who had clearly been assigned at the last moment. He carried a thin file and had the bearing of someone who would rather be on any other case. Douglas Fairfield was not present, his prerogative represented by counsel. Judge Mercer reviewed the case file for 2 minutes, then looked up. "Attorney Caldwell," she looked at me. "I see a substitution of counsel. Are you confirming you're entering an appearance for the plaintiff at this time?" "Yes, Your Honor." "And you've reviewed the case?" "Thoroughly, Your Honor." She nodded. No further comment. None of the hesitation I had braced myself for. It was Todd Kerrigan who hesitated. "Your Honor," he said, "we'd like to note our objection to the last-minute substitution of—" "The substitution was properly noticed," Judge Mercer said without looking up from the file. "We'll proceed." I didn't smile, but somewhere underneath the blazer, I exhaled. The hearing began with the defense presenting their position, that the settlement had been executed legitimately, with the plaintiff's full and voluntary consent, that all signatures were valid, and that any motion to set aside was purely dilatory. Todd Kerrigan spoke for 11 minutes. He was competent, good word choices, organized argument structure. But there was a weakness at the center of everything he said, and I knew exactly where it was. When it was my turn, I opened the portfolio. "Your Honor, the plaintiff moves to set aside the marital settlement agreement on 2 primary grounds. First, the plaintiff was in documented psychological treatment at the time of execution, with clinical records establishing significant emotional incapacitation. Second, and I am requesting the court's permission to present evidentiary material on this point, we have identified a document irregularity in the record that calls into question the authenticity of a foundational document in this proceeding." Todd Kerrigan shifted in his chair. Judge Mercer tilted her head slightly. "Go ahead." "The limited power of attorney through which the defendant claims the plaintiff authorized her previous counsel to execute the settlement on her behalf appears in the record dated March 22, 2022. However, the original filing entry in the Fulton County Superior Court records, an entry we obtained through examination of the physical filing log, reflects that this document was actually received and processed on September 17, 2022. A difference of nearly 6 months. Silence in the courtroom. "Additionally, Your Honor," I continued, in March of 2022, this court was operating under its hybrid filing transition protocol, meaning all in-person document submissions required a manual clerk stamp bearing the receiving deputy's signature and employee identification number. The power of attorney in question bears a digital filing stamp, which is inconsistent with the procedures in place on the date it purports to have been submitted. I placed the document on the table. The copy of the original filing log entry, signed and certified by Mr. Calvan in his capacity as a retired deputy clerk of this court, with 32 years of institutional knowledge, Plaintiff respectfully requests that the court direct the clerk's office to verify the filing record of the document in question, and that this matter be stayed pending that verification. Todd Kerrigan had gone pale. He stood. Your Honor, the defense would object. Defense will have an opportunity to respond, Judge Mercer said. She was reading the document I had placed on the table, reading it carefully, with the focused attention of someone who has found something that requires verification. And that's when the courtroom door opened. I saw her before anyone else did. A woman with close-cropped silver hair, dark slacks, and a cream silk blouse walked in and took a seat in the back row, the public gallery. She placed a small notebook on her lap. It took me 2 seconds to recognize her. The Honorable Harriet Voss, retired federal judge, 28 years on the bench in the Northern District of Georgia, 8 of them as Chief Judge of the Civil Division. Retired 3 years ago, now teaching at Emory Law. I had no idea what she was doing there, but Judge Mercer had recognized her too. I saw the exact moment their eyes met across the courtroom, the small nod of acknowledgement, the particular weight that comes from having a retired federal chief judge sitting in the back of your state court hearing. Judge Mercer turned to me. Attorney Caldwell, the document you've submitted identifies the source as a physical filing log from this court's records. Who conducted that review? Mr. Calvin Devers, retired deputy clerk of Fulton County Superior Court, employee identification number on file at the clerk's office, Your Honor. He is available to provide a sworn declaration or appear as a fact witness if the court requires. Judge Mercer looked at the document again, then looked at Todd Kerrigan. Defense. The young attorney remained standing 1 beat too long. I watched him calculate. I watched the moment he understood that there was no way to rebut this extemporaneously, because either the document was legitimate and the filing was irregular, or the document wasn't legitimate and the situation was considerably worse. Your Honor, he said finally, the defense requests time to investigate these assertions and file a substantive response. 30 days, Judge Mercer said. Matter is stayed in the interim. The clerk's office is directed to verify the original filing record for the document referenced by plaintiff's counsel and report to the court within 10 business days. She made a note. We're adjourned. As I was putting the documents back in the portfolio, hands completely steady, I heard footsteps. It was Judge Voss. She stopped beside me. For a few seconds, she said nothing, just looked at me with an expression I couldn't immediately categorize. Too serious for simple admiration, too personal to be purely professional evaluation. You worked in this courthouse, she said, not a question. 12 years, Judge Voss. I know. A pause. I saw you study here. I blinked. I'm not sure I recall us crossing paths. You didn't see me, she said it without any edge. Because you were reading. It was close to midnight, and you were sitting in the second-floor corridor with a federal civil rules manual across your knees. She looked at me steadily. I was leaving late from a conference call in Chambers. You were so focused you didn't notice me pass. I didn't know what to say. I stood there for a moment. One corner of her mouth moved slightly. I wondered who you were. A pause. It took me a while to find out your name. When I did, I kept track. She paused. From a distance. You knew I was going to be here today? I heard that Renee Fairfield's attorney had withdrawn this morning, and I heard you had stepped in. She closed the notebook. I came to see. Renee had been standing a few feet behind me, completely still, taking in every word. Judge Voss looked at her. You have a good attorney, Renee. Don't let her go. And she left. I stood in the middle of that courtroom that I had cleaned hundreds of times, portfolio under my arm, bar card around my neck, and needed 1 full second before I came back to the present. Renee stood closer. She didn't say anything at first. Then she put her hand on my arm, lightly, just enough for me to feel it. Thank you, she said. Her voice was different from how it had sounded when she arrived that morning. We're not done yet, I told her, but we're in the right place. I was not wrong. Over the next 30 days, the clerk's office confirmed the filing irregularity. The original log showed September 17, 2022, exactly as Mr. Calvin had identified. The 6-month discrepancy was not a data entry error. It was a structural inconsistency that could not have occurred by accident. The confirmation came on a Friday afternoon. I read the clerk's report twice, closed my laptop, went to the window, and looked at the rooftop of the building across from mine in Inman Park for about 3 minutes. It wasn't celebration, it was that specific calm that arrives when you spend weeks waiting for reality to confirm what you already knew, and it does. Then I called Renee. She cried. I let her cry for as long as she needed. Then I said, "Now we work." Hines, Kerrigan and Associates moved to withdraw from the case 3 days after the court's verification process was initiated. No public explanation, no formal statement. They simply stopped responding to court communications and filed a motion to withdraw. The stated reason was a professional responsibility issue that has come to counsel's attention. The actual reason was, we do not want to be on the wrong side of this when it fully surfaces. Douglas Fairfield was without counsel for 9 days. When he retained new representation, a smaller firm in Sandy Springs, without the institutional weight of his previous choice, settlement conversations began within 48 hours. I sat across the negotiating table with Renee beside me, a list of rights she had been systematically denied in the original agreement, and the patience of someone who had waited 12 years to be at that table and was not in a hurry to leave it. The attorney on the other side tried, in the first 2 hours, to minimize the financial exposure, tried to recharacterize the document issue as an administrative error that doesn't reflect intent, tried to propose a faster resolution at lower numbers in exchange for a confidentiality clause covering the filing irregularity. At each attempt, I opened another section of the case file I had built over 4 months, not for effect, for precision. At hour 3, he asked for a recess. He was gone 20 minutes. When he came back, the tone was entirely different. The negotiation lasted 2.5 days. In the end, Renee received what had always been hers: equitable division of the assets accumulated during the marriage, spousal support for 5 years while she rebuilt her career, and damages for the manner in which the original proceeding had been conducted. The total reached $1.4 million between the revised settlement and the damages award. It was less than the theoretical maximum and more than the other side wanted to pay. That is what a good settlement looks like. Additionally, the matter was referred to the court's presiding judge for possible referral to the U.S. Attorney's Office for fraud on the court. The investigation into the document irregularity is ongoing. That's not my case to litigate. My job was to make sure Renee was protected. What happens next follows its own trajectory. Douglas Fairfield, whose face appeared in the Atlanta Business Chronicle every quarter, is going to face proceedings for fraud on a court of law. In the weeks after the settlement, I heard through mutual connections that Paulette Ashford Crane, who had seen me on my knees scrubbing courthouse floors, had grown quiet at social events. That when she tried to bring up the matter at gatherings, the polite silence from those around her was sufficiently clear. That her husband, Judge Warren Crane, had received a phone call from a colleague who had been in the courthouse hallway that morning and felt it was worth mentioning. That she had canceled a charity gala she organized every November, without public explanation. I was not there to witness it. I didn't need to be. Sometimes the most significant consequence isn't the case lost or the money paid. It's the moment when the people in your circle stop looking at you with uncomplicated admiration and start looking at you with that careful consideration reserved for someone they're no longer entirely certain about. In those circles, that shift is its own currency. And Paulette spent some of hers. Today, it has been almost 2 years since that morning in the hallway. I live in the same 1-bedroom apartment in Inman Park. The succulent on the windowsill is still alive. It survived 2 Atlanta summers without consistent watering, and I consider that a positive sign. The desk in my home office gained a second chair, a printer that only jams when the paper tray is overfull, and a desk lamp I bought on a Saturday morning at the Ponce City Market flea fair without calculating whether I had enough in checking first. That last detail sounds small. For someone who spent years calculating every purchase before putting it in the cart, it is not small. I have 17 active clients. Most are women, in divorce proceedings, in custody disputes, in situations where someone with more resources tried to use those resources to erase what they were entitled to. I represent 3 of them pro bono, not because I can afford that financially, I can't yet, but because I know what it is to be on this side of the table with no one who speaks your language. I'm building the firm's website. It's basic, still. With a bio I rewrote 7 times because every version sounded either too arrogant or too small, and neither one is right. My niece, who's 19 and studying graphic design at Georgia State, is helping me with the layout. She wants to intern with me next summer. I said yes before she finished asking. Renee, you ask? She went back to work. She launched a residential interior design consulting business, a skill she had developed across 16 years of marriage without anyone acknowledging it as a skill. All those years managing properties, selecting finishes, overseeing renovations, everything her ex-husband treated as what she does while I work turned into, with solid footing, a real practice. She texts me sometimes. Last week she sent a photo of the first apartment she signed a lease on by herself. Just hers, with a plant on the windowsill. I understood the reference. Mr. Calvin came over for coffee last month. He brought a pound cake his wife made. The kind you eat a slice of and go quiet for a second because it would be wasteful to talk through something that good. And he sat for 2 hours telling me old courthouse cases from the 90s that he keeps in his memory with the precision of someone who took the work seriously for 3 decades. Before he left, he looked at the bar certificate on the wall, the one I framed and hung up the first week after I passed, and said only, "About time." 2 words. I needed a second before I could respond. From Judge Voss I didn't hear anything after that day in the courtroom. But 1 week after the hearing, I received a letter, on paper, sent through the mail, handwritten, with no return address beyond, Atlanta, GA. It said only, "People who study in service bathrooms at 3 in the morning tend to know more than people who studied in well-lit offices. Well done on the conduct of that hearing. HV." I kept the letter. It's in the second drawer on the left, in a clear plastic sleeve so it doesn't yellow over time. There are nights, when it's late, and I'm alone rereading a difficult case, one of those that seems closed but has a gap you haven't located yet, when I open that drawer and read it again. Not to remind myself that I won, to remind myself that it was worth it, that every sleepless night was worth it. Every page, every time I kept going when I should have stopped. Every $12 textbook from the used bookstore on Moreland Avenue. Every pound cake sold out of a cooler. It was worth it. And now, I need to tell you something. Not about me, about you. If you work somewhere today where the hierarchy seems like an excuse to treat you as less than what you are, I want you to hold on to what I'm about to say. Not as empty comfort, as real information that can change your situation. Workplace harassment, that systematic pressure, the constant diminishment, the comments that undermine your competence or your humanity, has a legal name. It has a legal definition, and it has legal protection. Every worker in every position has the right to be treated with dignity. That is not a courtesy. It is a right. Domestic workers, housekeepers, cleaners, nannies, cooks, personal assistants. In most states, you have the right to a written contract or clear agreed terms. To workers' compensation if you're injured on the job, to be paid what you were promised and on time, to freedom from a hostile and abusive work environment. If you are working and those rights are not being honored, you are not being done a favor. You are being stolen from. Documenting is the first step. Save messages, write down dates, keep records of amounts. Everything that came through in writing, save it. Everything said in front of witnesses, note it down. Memory is unreliable. Documentation isn't. If you suspect your rights are being violated, seek free legal guidance. It exists. The Legal Aid Society, your state bar's lawyer referral service, law school clinics, and nonprofit legal organizations offer free or low-cost consultations for workers in every major city and many smaller ones. The National Domestic Workers Alliance has resources specifically for domestic and household workers. You don't have to know exactly what law was broken to make the first call. You just have to start telling your story to someone who knows how to listen to it with the right eyes. Workplace abuse in domestic and household employment is especially hidden because it happens inside private homes, away from witnesses, inside a power relationship that is profoundly unequal. But hidden does not mean immune. It means you need someone who can translate what you lived through into the language the system understands, and you have the right to access that help. If I had known all of this earlier, I would have acted much sooner. That's why I'm telling you now. No one, with whatever money, status, or authority they hold, has the right to use it to make you feel like less than what you are. That is not leadership, it is abuse, and abuse has a name, has law, and has consequences. You made it to the end of this. That already tells me something about you. If this story reached someone who needed to hear it, share it. Send it to a friend, send it to a sister. Send it to anyone who is right now enduring what they shouldn't have to endure because they don't yet know there's a way out. Tell me in the comments, have you ever known someone, or been someone, who stayed in an unfair situation for a long time because they didn't know they had the right to leave? What would you say to that person today? Thank you for staying until the end, for listening, for mattering. Stories like this one exist to remind us that competence doesn't have a zip code, doesn't have an address, doesn't come with a uniform, and that underestimating someone because you never stop to ask who they are might be the most expensive mistake you ever make. Until next time, take care of yourself.